Thanks for being here. Our panel is distinguished indeed. I will introduce them by order of appearance. We will have Matt Fitzwater from Sullivan and Cromwell kick it off with a discussion of whistleblower provisions under Dodd-Frank. Then Sylvia from Phillips and Cohen will give the plaintiff side rebuttal. We will have Albert Lin from Ice Miller to talk to you about consumer protection. Not mentioned in your bio is that Albert Lin was general counsel to Rich Cordray when Rich was Ohio Attorney General. And then Julie Reiser from Phillips and Cohen will also talk about consumer protection. And finally, Rick Holmes from Fifth Third Bank will talk about derivatives.
Okay, well, great. Thanks for everybody coming out this afternoon. And this is the last program of the day, so I know everybody's excited and ready for the awesome things we have to tell you, and that's great. As Professor Chang said, my name is Matt Fitzwater, and I'm with Sullivan and Cromwell in New York, and I practice on the defense side. And I feel like, given the course of today's presentations, maybe I should entitle my piece, Why Banks Are People Too. Maybe, thank you. That was for Rick. So as Professor Chang said, what I'm here to talk about is the whistleblower provision of Dodd-Frank, and then practically from a practitioner's point of view, what that means. I mean, we don't entirely know what it's going to mean because it's very new, and then what people ought to be thinking about in terms of its implementation and what its impact might be. So Dodd-Frank was enacted back in 2010, and in Congress's infinite wisdom, they decided to put in there a whistleblower provision, but left it to the SEC to put the rules in place to see how it would work. You could see in the midst of the financial crisis and post-Madoff, the idea of a whistleblower provision would be very attractive, giving each citizen, each employee the ability to come to the government and self-report something they believed to be a violation of law was a very popular idea at the time. Well, the SEC had a very tight deadline, and they were putting their rules in at the end of 2010 for comment, and a lot of comment there was, kind of from both sides of the aisle, some people fearing that the concept of whistleblower provision was going to result in a lot of frivolous claims that would then bog down both the SEC and institutions through investigations, and others pointing out the recent lessons of the financial crisis, that we needed something in place in order to make sure that if people were aware of something, they had a direct pipeline for it to be reported, and that then it would be, there would actually be action taken. So under the whistleblower program that came out of this, eligible whistleblowers are entitled to an award of between 10 and 30% of the monetary sanctions collected in actions brought by the SEC and related actions brought by other regulatory and law enforcement authorities. And in order to qualify for the whistleblower award, the information provided must lead to a successful SEC action resulting in an order of monetary sanctions exceeding $1 million. Again, this was hotly debated and hotly contested. The idea of tying, a monetary award or a monetary bounty to the provision of information, again, concerned a lot of folks maybe on the defense aisle that this was going to bring forth, people who either had frivolous claims or were in a hurry to report things in the hope that they might be entitled later to a monetary award. Well, in order to be an eligible whistleblower, it's a person who voluntarily provides original information about a possible violation of the federal securities laws that has occurred, is ongoing, or is about to occur. So there's a lot of important information in there. First, it needs to be voluntary, and that means you have to give the information before it's requested by the SEC, Congress, or other enforcement or self-regulatory organization. You can't be a whistleblower if you're under subpoena and then you provide information truthfully, no matter how much you'd like to be, I guess, at that point. It also has to be original information, which means it has to be information derived from the whistleblower's independent knowledge or independent analysis that is already not known to the SEC and is not otherwise publicly available. You can't read the Wall Street Journal and call the SEC and go, "You won't believe what I just heard." This is serious stuff. And in order for it to qualify as leading to a successful SEC action, it has to cause the SEC to open a new investigation reopen a previously closed investigation, or cause the SEC to pursue a new line of inquiry in connection with an ongoing investigation. So there's a lot of factors that are in play in order to qualify successfully as a whistleblower, and I think some of these provisions were put in place to maybe assuage some of the concerns that people had about the program to begin with. Now, one of the hotly contested provisions of the whistleblower program, and I fear where Claire and I are going to disagree as she is giving the rebuttal to what I'm about to say, is that internal reporting at the whistleblower's place of employment is not required in order to qualify for the whistleblower award. What this means is the individual can report directly to the SEC and not go to its employer first in order to qualify for the award. Now, however, under the program, a person can be eligible for the whistleblower award for information reported internally if the person also reports the information to the SEC within 120 days of reporting it internally. So if the person reports it internally, they can still qualify for the award if they do it within 120 days of reporting it internally. And the employees who report the information internally first then receive the benefit of all the information uncovered by the company or institution in connection with its own internal investigation of the alleged wrongdoing, which in theory is meant to be an incentive to report it internally, because then you wouldn't just get the benefit of what you're reporting, you would get the benefit of what the company also might uncover in connection with your report to them. Now, as I said before, the whistleblower award can be between 10 to 30% of the monetary sanctions collected, where those sanctions are more than $1 million, but there's a range. And the award can be increased based on a number of factors, including the significance of the information provided compared to the success of the proceeding brought against the wrongdoers, the extent of the assistance provided, so a tip versus maybe more information or interviews from the individual, whether and to the extent the individual participated in their company's internal compliance and reporting program, again, meant to be an incentive that if you do report internally, that would be a kind of an up factor, an increase of the award you could get. Now, the award can be decreased on a number of factors. The extent to which the person was culpable in the conduct they reported. For instance, you blow the whistle on yourself. Listen, I've got serious concerns about me. If you'd saw what I did today, I'm just saying you should look into it. Other factors that may result in a decrease, an unreasonable delay in providing and reporting the information, and if the person interfered with their company's internal compliance and reporting program, such as making false statements to compliance as part of an internal investigation. So even if you didn't report internally first, you just went straight to the SEC, you can't then lie to company counsel who are trying to investigate the same issue and expect to get a bigger reward. In addition to the award under the whistleblower program, whistleblowers are also given retaliation protection. Employers can't discharge, demote, suspend, harass in any way, discriminate against a whistleblower because of any lawful act done in providing the information as a whistleblower. And if an individual believes they've been retaliated against, they can potentially seek relief in court, where they could seek reinstatement, back pay, litigation costs, and attorney's fees. Today, the SEC has an Office of the Whistleblower, which is headed by Sean McKessie and a staff that reports to him of 8 employees, and their job is to field these whistleblower reports and then fold them into the investigations that are going on at the SEC. So that is, kind of an overview of how the whistleblower program works. I did not have a PowerPoint. I have a very good reason for that. I have no idea how to do it. So I appreciate everybody bearing with the oral presentation with no fancy pictures to put on the screen. Well, I'd like to, now that you have kind of an idea of how it works, I'd like to maybe give an example, and then from a defense attorney's perspective, a company's attorney's perspective, how I think that the whistleblower provision may not necessarily be as great as it sounds, and can potentially work against companies cleaning up behavior on their own. Maybe as a hypothetical, you have let's say Matt Bank, named after me, I'm Matt. You have Matt Bank, and one of the employees at my bank, John. John believes that he has seen potential violations of the securities laws. He has serious concerns that that's going on at my bank, and he's presented with a couple of options, right? One option he has is to do nothing. He's like, maybe I'm not the only person who works there. Other people may have seen the same thing. I had equal access to the information. I'm better off, not saying anything at this point, which is a choice somebody could make. Two, well, what John could do is he could come to compliance at Matt Bank and raise the issue with compliance and talk it through with them, which would inevitably lead to a number of actions, including probably an internal investigation at Matt Bank and either the use of internal or external counsel to look into the issue, and then the bank itself, after looking at it, may themselves decide to report the information. And kind of choice 2B is that John could report it to compliance, and then within 120 days, report it to the SEC and still qualify for the whistleblower program. Or 3, Matt could not go to compliance and never report it internally to the company and go straight to the SEC. Well, I think that hypothetical illustrates some potential problems. Not every, and in fact, most companies and institutions in this country I think are run by honest and responsible people, and certainly when you're dealing with companies that have thousands of employees, the vast majority of people on a day-to-day basis are trying to obey the law and to do what's right. And so you want to, I think, encourage, when there is misconduct or potential misconduct going on, I think you want to encourage people to report that internally so something can be done about it. But given the way that the whistleblower program is currently constituted, while people may have a financial incentive in the long run to go and report this internally, it gives people the opportunity to go straight to the SEC and never report the information to the company. Why might that be bad? Well, as I said, I think most companies do try to operate themselves responsibly. So if the person is going directly to the SEC and is never reporting it internally, then they're not giving their company, who may very well want to do what's right, the opportunity to stop the conduct, right? If there's potential violations of the law going on, they go to the SEC, and the company doesn't know about it, and so in this sea of thousands of employees, the company is not able to necessarily root out what may be going wrong at their institution, with what could be a rogue few employees that are doing something improper. So it creates that very real possibility that may happen. It also creates another strange dynamic in that if they're going directly to the SEC, later on the company conducts an internal investigation, and while the person, in order to qualify for the award here, can't lie or mislead the investigators, that doesn't necessarily mean the person has to volunteer that they were the whistleblower, or even volunteer the information on which they blew the whistle. So again, it could serve to frustrate a company's internal compliance program, which otherwise is geared toward making sure that the company is being responsible and is doing the right thing, and making that more difficult to do. So I think it presents potentially a very odd dynamic between companies that may want to be responsible, employees that are concerned about improper conduct going on, but then not giving the company's compliance program the opportunity to do what it would want to do. Now, anticipating some of the comments that Claire would be right to make, is that the reason employees might not feel comfortable going to company compliance or to someone within their company and raising the issue is the fear of reprisal, fear of demotion, how it may impact their working life, the stress that would be associated with raising those kinds of issues internally. And I guess from a practitioner's point of view and a defense point of view, the way to you can't guarantee that employees will self-report internally, but a way to maybe bridge that gap and encourage them to do so is to foster a strong compliance culture so that they believe that if they go to compliance, that information isn't going to be used against them and is going to be judged fairly. Setting up a number of different pipelines for people to report information that they're concerned about, including being able to report it confidentially and anonymously. A lot of companies have 24/7 hotlines, anonymous tip lines that they can use, often run by third-party vendors, so it's not as if they're calling the line and one of their fellow employees are picking up the phone on the other end. So there are a number of ways, I think, to encourage employees to come forward, and it really does serve everyone's interests if the company is being responsible and listening to what the employee has to say, and the employee comes to them directly, because responsible companies, they want to find out about the conduct, and I think they want to stop it if it's improper, or at least look into it, and certainly not everything that people may be concerned about at the end of the day was wrong, and so it gives the company a chance to look at it, and if it's concerning, address it, and otherwise explain to maybe the employee who raised it why it wouldn't be an issue. So what has the whistleblower provision meant practically in practice? Well, it hasn't been in existence very long, so it's hard to say exactly what it might mean. But certainly some more recent experience I've had with the SEC enforcement staff is I found them increasingly secretive, increasingly less likely to provide you information, not just about who may have raised a concern at your company, but what the concern even is. I've had investigations where we were several months into the investigation and the staff was still unwilling to tell me what it is they were even investigating, and the requests that were made were so broad and covered so many people and issues that it would be impossible to determine what the issue might be. And again, what interest does that serve? I don't think it serves the interest of stopping the conduct, because then you leave the company in a position for several months at a time not knowing what the concerns may be, or what the conduct may be, or what employees are involved. So I don't think it serves that interest. And it also doesn't serve the interest of really assisting the SEC in its investigation. While it's not true across the board, a number of companies, when they are approached by the SEC or other regulatory agencies, do want to assist the investigation, do want to cooperate, do want to provide the information. But if they're not being told in the slightest what the concerns or issues are, doing so is very difficult. And I can't imagine on the SEC side of the aisle that itself is very helpful to their investigation either, because being bombarded with large volumes of information and data without the company maybe being able to guide you to what may be relevant, I don't think is probably an efficient way to investigate, and it certainly isn't efficient or cost effective for the company who's being presented with the request. So I think there has to be some reasonable middle ground, and I think there are things companies can do to encourage their employees to come forward and raise concerns they have on a timely basis. And I also think on the SEC side, there are things they can do to help companies cooperate with their investigation, because a number of companies do want to do the right thing.
Thank you, Matt. Now we have Claire from Phillips and Cohen.
Thank you very much. I want to say thank you to the College of Law and Professor Black and Professor Chang for inviting us. It's an honor to be here to discuss some issues with you that are very dear to our hearts. As I mentioned, my name's Claire Sylvia. I work with Phillips and Cohen. Our experience is primarily with perhaps the more well-known key TAM provisions of the False Claims Act, which deals with fraud against the federal government and now increasingly state governments. The Dodd-Frank whistleblower provisions were built in part on that. It wasn't a program that came out of the blue and people just said, hey, here's an idea, let's pay people to give us information. It's actually been happening for a long time in the federal government in other contexts. The SEC program draws on some of those ideas, but not all of them. And so one of the things I'm going to talk to you today about is the difference between the two programs. I didn't really see my charge as a rebuttal to Matt, but to talk a little bit about the process and the difference between this program and the False Claims Act program. And then I did anticipate the idea that we'd have different views about internal compliance. So I have a few words to say about that. But the whole program is so hypothetical at this point that I think there's probably much agreement because not too much has happened yet. And we're all talking about things that are possibilities. So I want to pause for a minute. We've talked a lot during the day about the impetus for Dodd-Frank. And for the whistleblower provisions, there's that word again, Bernie Madoff. In the wake of the Bernie Madoff scandal, there was a lot of calls to have some kind of more institutionalized whistleblower program at the SEC than had existed previously. Before that, you could report to the SEC, but there wasn't really a formal mechanism for ensuring that something happened. And so that was what sort of the demand was for. Now, I will just pause to say I don't know if Madoff's firm had an internal compliance program, but if it did, it probably wasn't working so well. And it also points out one of the problems with some of the entities that we're talking about. Obviously, lots of companies want to have internal compliance and want to obey the law and deal with problems promptly, but sometimes the fraud is the institution. And what kind of compliance can you have in that sort of circumstance? Or the people in charge are involved. And it's quite a difficult thing for someone lower down on the corporate ladder to report to those people. So a little bit more about that later. So the law did lay out the program pretty clearly. The SEC did adopt implementing regulations that by and large track the law, fill in some gaps, and they became effective in August 2011. There were lots and lots of comments, lots and lots of debate. I think it was called the deregulatory effort earlier. But by and large, I think the SEC struck a pretty good balance on a lot of issues, including the internal compliance idea. So as we've already learned, and I'll skip through this quickly because there's no debate about it, although I will point out, and maybe this is by way of rebuttal, I thought it was interesting that Matt began with rewards, success, information. I'm going to begin the other way, information, success, rewards. We don't really think about this or present it to our clients as, hey, here's a lottery ticket, report and you get money. It's not really the way it works. You have to have information. To be a whistleblower, you have to be an individual or someone together with another individual. It can't be a corporation under the SEC whistleblower provisions or some kind of corporate entity. You have to voluntarily provide the SEC with original information about a possible violation of the securities laws. It has to lead to a successful SEC action or actions. They can be multiple ones, and it can be related actions. Sometimes it can be something enforced by another entity, such as the Department of Justice, and has to result in monetary sanctions exceeding $1 million. So those are some of the threshold requirements. Voluntarily, as Matt pointed out, you can't get a subpoena from the SEC and turn around and blow the whistle on yourself, or from other regulatory authorities. And it can't, the subpoena or the request for information can't come to you, your organization, or someone who represents you, for example, your lawyer. So it has to be voluntary in that sense. And it doesn't actually have to be a subpoena. It can just be a request for information. The information is not provided if you had a pre-existing duty to provide it, or contractual duty, or under some judicial or administrative order. It's very important to be voluntary. We already heard about it has to be original, has to be derived from your independent knowledge or independent analysis, can already be known to the SEC from another source, unless you're the person who told that source. So if you went to Congress and said, here's a problem, Congress told the SEC, you can still go to the SEC. It can't be exclusively derived from an allegation made in certain other places, again, unless you're the source of the information, for example, a judicial or administrative proceeding. And obviously, it has to be provided after the enactment of Dodd-Frank. You can't have gone to the SEC before Dodd-Frank was enacted and claim a reward for that. However, you can go after it was enacted and claim a reward for conduct that occurred going back. Independent knowledge, again, is facts known to you that aren't derived from the publicly available sources. But, and this is important, it can be independent analysis, which is there can be information floating out there. The information's out there, but no one knows what it means. And that can be independent analysis and a basis to go to the SEC. And that's a very important idea because the government, the SEC, they have lots of information. Tons of information, but they might not know what the whistleblower knows, which is what that information means and how it is a particular type of fraud. There are certain people who cannot be whistleblowers, and there's a list of them, and when I'll get to the form that you file with the SEC, which actually requires you to say that you're not one of these people, they include people like the lawyers for the company, so sorry, Matt, can't be an auditor, you can't be compliance program personnel. Now, for each of those, there's also certain exceptions. So if there's a need to prevent harm, that's an exception in certain cases for officers of the company. For lawyers, even, there's an exception if under the state bar rules, you would be permitted to breach confidentiality, you may be able to report. And so there are a number of those kinds of exceptions. Anonymous filings, this is very important. The SEC, if you want to, you can report anonymously. So not even the SEC knows your name when you report. But if you do, you have to be represented by a lawyer so that your lawyer is sort of the face, your face to the SEC and someone that they can communicate with. But to do that, you also have to fill out a form, the same form everyone else would fill out, under penalty of perjury. Give it to your lawyer has to keep it, so if one day the SEC wants to demand it, to make sure that you did not engage in providing false information, that has to be on file. So it's very important protection because some people are just afraid to report if they think that their name's gonna be come out. What can you report? Violations of the securities laws. There's a long list. These are just representative: insider trading, accounting fraud, false or misleading information, the Foreign Corrupt Practices Act. We could go on, but the SEC was required to do a report every year on the whistleblower program, and they recently did one in November. Not too much had happened by then, but they did report 2 months of activity and for September and August. And this is how people self-reported the types of actions that they were bringing. Market manipulation, offering fraud, trading and pricing, insider trading, corporate disclosure, Foreign Corrupt Practices Act, municipal securities, unregistered offerings, market event, and other. Other was a very big category, people who didn't say. So that gives you some kind of picture of the things that the SEC is seeing. Foreign Corrupt Practices Act, that's received a lot of attention. Both the SEC and the Department of Justice have responsibility for enforcing that. One of the reasons it's received a lot of attention is before this, there wasn't really a way for private individuals to be involved in the enforcement of the FCPA. There were theories under which you could bring such a case under the False Claims Act if the federal government was defrauded of money as a result. But this is sort of a unique way to start enforcement of the FCPA through a private person. Rewards, I'll get to there at the end. They're in the discretion of the SEC. They are between 10 and 30%. There are factors for increasing award that Matt already went through. They're not that dissimilar to the False Claims Act. The most important thing is the significance of the information provided and the assistance provided by the whistleblower. This is important, the SEC's law enforcement interest in deterrence, and then participation in the internal compliance program. And that factor is one of the ways that the SEC balanced this concern about internal compliance. They said, look, we're going to encourage it by telling people that if you do that, that'll be a factor in your favor at the point we get around to awards. Factors for decreasing culpability of the whistleblower, unreasonable reporting delay, and interference with internal compliance programs. Procedure, just quickly, the SEC has come up with a form called the Tip Complaint or Referral Form, TCR form, that's on their website. You go in there, you fill it out, you put in your name, your information, sign it under penalty of perjury. It's very easy to do. Then what happens? Well, this is where it departs from the False Claims Act a little bit. The SEC investigates, and they do whatever they do, and you wait. You try and help if they want your help. Some whistleblowers have a lot of expertise in a particular area. They may meet with the SEC. They'll certainly be interviewed by them. But primarily, the SEC is in charge, and the whistleblower isn't a participant except to the extent that the SEC is interested. They don't have a right to be part of that process. So we might have lots of ideas about how they could run their investigation to be helpful to the company, but that's not really part of the process. If and when the SEC is successful in one of these actions, and no one's seen that yet, although they're starting to, it will be reported on their website what the action was, when it happened, and you can check the website and see if a case that you think you gave information about has been reported. They're hoping in the end to be able to give you individual notification, but right now that's not actually a requirement. So you have to go on the website and check periodically to see if a case that you might have an interest in has been successful. When you find that, you have to submit a form making an application for an award, and that's the process. Now, quickly, the difference between this and the False Claims Act, and I think it's really important because some people have referred to the SEC whistleblower provisions as qui tam provisions, which they really aren't. And that's because the main difference is there is no action forcing mechanism in this process. You give your tip to the government and that's what you do, unless they let you do more. The False Claims Act is very different because you file a lawsuit, and eventually something's going to happen. The court's going to say what's going on with that lawsuit. It's going to make you go forward. It's going to make the government go forward. So the SEC program, we don't yet know really what's going to happen, how it's going to work. It was very important in the False Claims Act context that the plaintiff have a stake in the litigation and be able to participate and be an active player in seeing that something happened to their information. You don't really have that with the SEC provisions, but maybe that's a balance in going slower in regulation. Let's see how this works. If it works well, then maybe it's good enough. It's not overseen by a court. Obviously, if the SEC files a litigation, it is, but this particular tipping process isn't. There are very strong confidentiality provisions in the SEC mechanisms, less so when you're litigating a case. Your identity is more likely to become known under the False Claims Act. Percentage of recoveries are different. It's 15 to 25% in the FCA if the government joins your case with you. If they don't join, you get a higher percentage. But again, with the SEC, there's no concept that you would pursue a case without the government. There's only the government's case. The FCCA, the reward comes out of each case. The SEC has a unique thing, which is a fund, which is going to fund these rewards. It now has a lot of money in it. They haven't given any of it out yet. Internal reporting debate. As I said, the SEC struck a balance. There was a big debate. Is this fact that you don't have to go report internally before going to the SEC going to be a problem? And the SEC decided that there wasn't very much to support the idea that people would rush to the SEC to give information and that would harm companies in some way. There's certainly information and experience from other areas to suggest that's not the case. There are a lot of reasons why people don't go to internal compliance, including that they very often get fired. There are a lot of reasons a company would want to know who's reporting and what they're reporting. And they're not all good. Some of them may be good, but they're not all good. If I were a lawyer representing a company, I would certainly want to know who the whistleblower was and what the government knows. And why? Because I think it was Professor Pan was saying in another context, information is king. If you know what the government knows, you're going to have a better time defending against the case, not just in terms of telling the government everything it needs to know, but not telling the stuff the government doesn't know. Information is very important. And that's the whole idea of the whistleblower provision, which is that it's an information revelation model. We will offer people money to report information to the government that the government doesn't have and despite the best internal compliance programs isn't likely to get. The internal reporting debate has continued because even though the SEC has resolved it in its rules somewhat by having this balance, there's now even a bill that was introduced in the House that would require internal reporting. People haven't really given up on this idea. But the SEC has recently found that most people, and this has certainly been our experience, did report somewhere before going to the SEC or the government. Certainly true in the False Claims Act. Almost everyone we represent told someone about the fraud, and the reason they come to us is because nobody listened. Anti-retaliation provisions, there's also what some people think of as whistleblower provisions, which is that if you lose your job, you can sue. This actually is a private action that you can bring in federal court to recover, get reinstatement, back pay, attorney's fees. It's very important to tell people that there are protections in case they do get fired, but the reality is that this is much less protective than the idea that if you put your career and your future circumstances of a career in an industry on the line, that you might actually get a reward that helps you more than pay you back for 1 or 2 years of lost employment. So with that, I will turn it over to our next speaker.
Thank you, Claire. Next is Albert Lin from Ice Miller, who will talk to you about consumer protection.
something. This one? Look at that. Wow, that's amazing. Okay. So thank you, Felix, for having me today to talk a little bit about the Consumer Financial Protection Bureau. We have a very accomplished and august panel. Still not sure why I'm here. Oftentimes people ask me to talk a little bit about Rich Cordray. I worked with Rich very closely for a couple of years at the Ohio Attorney General's office and have been interested in what he continues to do. The Consumer Financial Protection Bureau was established in 2010 under the Consumer Financial Protection Act. Rich was recently elevated as director. Prior to that, he was the chief of enforcement. And this brand new regulatory agency has the authority to implement and enforce federal consumer financial laws. What does that mean to the general public? It means stuff like credit cards, student loans, debt collection, and payday loans, which is a real focus for the CFPB right now as a kind of unregulated financial products market. As lawyers, we're required to put up things like implementing legislation, though people often aren't interested in those slides. So, the jurisdiction of the CFPB is wide. These are the types of things that the CFPB has more or less plenary jurisdiction over. Consumer credit and loans, real estate settlement services, check cashing, electronic payment services, any interface a consumer has with the financial system in many ways falls underneath the jurisdiction of the CFPB. One of the reasons the CFPB, as a policy matter, was such a focus in the Dodd-Frank Act was that consumer financial laws are really a tangle. These are all of the laws that the CFPB is currently authorized to enforce or implement rules on. It would take all of my time to just list the laws that are trying to be simplified and coordinated through this regulatory agency. The CFPB also seeks to consolidate regulatory power from multiple and often conflicting federal regulators into one organization and under one director. And so the Office of the Comptroller of Currency, Thrift Supervision, FDIC, and other functions are being consolidated within this agency. These are the stated statutory objectives of the CFPB. This is its regulatory mandate to give timely and understandable information to consumers. As with most consumer protection statutes, to protect the public from unfair and deceptive practices, to streamline industry regulations. So for example, there would often be regulations from different regulators that were in conflict. The idea, at least, is that the CFPB, because it's one organization, can smooth through those regulatory tangles and implement and simplify regulations that relate to consumer financial products as a whole. Make sure that consumer financial laws are enforced consistently and to give more transparency and efficiency to the market for those products. Its regulatory functions, there's a very, and is broken down to several different offices. There's an Office of Financial Education, research, collection of data, enforcement, one of the largest offices, and a regulatory function. The CFPB has substantial rulemaking authority. Again, these are some of the statutory prerequisites. The director is required to weigh the costs and benefits of rules to consumers in the industry. It is authorized to enforce the pre-existing rules of other agencies, and it will report yearly to Congress about market risks for consumers. What are the types of institutions that the CFPB regulates? There are really chunked out into two basic types, banks and non-depository institutions. So here are some examples of what would be a non-depository institution that the CFPB currently regulates. Mortgage brokers, mortgage servicers, people who originate loans for real estate. Generally, mortgage loans are not considered a consumer financial product, but many of the functions relating to mortgage brokerage services, origination, and servicing are. Institutions can be brought underneath the supervision of the CFPB through a complaint process and other kind of consumer products such as payday loans and private education loans that come from non-depository institutions. Non-depository institutions are subject to periodic reporting and examination depending on their asset size, volume of transactions. That type of regulation should be coordinated and is coordinated with state oversight. The CFPB has substantial enforcement authority for these non-bank companies that work in the consumer financial space, and they are subject to the rulemaking of the Consumer Financial Protection Bureau. This really is the focus of the CFPB from a wide angle policy perspective, is to implement new regulations and help make the market for example, payday loans, private student loans, more transparent and work better so that there is less problems with consumers. The CFPB also pulls underneath its jurisdiction supervision of large banks, depository institutions. Large banks and credit unions, as under the prior regime, are subject to periodic reporting and bank examinations for banks that are, and credit unions that are over $10 billion in deposits. The CFPB has enforcement authority relating to the consumer financial products promulgated by those banks, rulemaking authority, and bank examination. So here's, what do large banks, what are some large banks? Here is a good, to kind of make it more practical, the large banks in Ohio. These are the banks and the institutions that are going to have a lot of substantial interface with this new agency. And here you list out from 2010 the assets under the deposits that each of these institutions have, ranging from First Merit, a very regional Akron-based bank, all the way up to JP Morgan Chase. Rick, there's Fifth Third up there, just so you know. So, banks below $10 billion are not subject to the same type of periodic examination as large banks. It is up to the CFPB how often they go in and perform the examinations. But those banks are still subject to the same rules and enforcement authority that the CFPB has the power to enforce and regulate. The Dodd-Frank bill was subject to substantial lobbying, and some of these excluded entities were very successful in keeping their membership outside of the scope of the CFPB. Merchants and retailers generally are not subject to the CFPB except when they engage in credit card or gift card functions. Real estate brokers are not within the CFPB, accountants, tax preparers, except when they offer loans based on, for example, your tax return. That would be a consumer financial product that, for example, H&R Block would be subject to. Thank goodness lawyers are not subject to the CFPB. And state insurance laws have not been preempted by the CFPB, though many people view insurance products and insurance companies as consumer financial companies. Investment professionals, notably, are not within the auspice of the CFPB. And here you have the the auto dealer, what is known as the auto dealer exception, which was subject to a very large lobbying effort, where financing and other types of lease arrangements relating to, purchase loans or lease loans for cars are not pulled within the regulatory authority of the CFPB. The statute generally preserves state law, allows the CFPB and encourages the CFPB, frankly, to coordinate with state AG's office. State AG's office have a parallel authority to enforce both state and federal law. Its enforcement powers relate, everyone thinks of enforcement as litigation relating to these products, but much of the enforcement activity is pre-litigation relating to investigations and processes that don't end up in litigation. That's a basic background of the Consumer Financial Protection Bureau. People have asked me, how they think Rich is going to manage the organization. And this is what I would say. Rich is a very talented lawyer, very accomplished regulator, and he's going to do a great job. He generally has a very multidisciplinary management style and tries to seek consensus from various people who have jurisdiction over topics where he has to render a decision. So oftentimes there'll be very large meetings in which people will weigh in and some sort of consensus-based decision will be made. His decision-making process is very deliberative and fact-based. It's very consistent with his background as a practicing attorney. I think the basic principles that he works under when he works with financial markets and regulation related to financial markets is that any implementation of regulation has to be very transparent and it has to be very deliberate so that persons within or companies within that landscape have the ability to revise, if necessary, their activities in a structured process. His view has always been that with an even landscape, our system of competition and capitalism can really flourish as long as the rules are very clear and very evenly enforced. So those are my comments. Thanks a lot.
Thank you, Albert. Julie Reiser from Cohen Milstein will be talking to you about consumer protection issues as well.
Good afternoon. Thank you, Professor Chang and Professor Black, for inviting me to speak today. When I was invited to speak, I started thinking about the consumer provisions, and as a litigator, what things looked like they'd be interesting and what we might end up trying to enforce down the road. Everybody keeps talking about the fact that Dodd-Frank is relatively new, so that much of this remains to be seen. But it struck me that as I was thinking about these things, a client called and asked me a question about Dodd-Frank. We were talking about the various options, and at some point he said to me, well, what if I don't want to litigate? And I laughed and I said, that's like asking a surgeon, what if I don't want surgery? I have no idea. But maybe you could find somebody else who can help you with that question. So I give you that caution as I speak today, that I have been looking at this as a litigator would and looking for ways in which I think as a plaintiff's securities lawyer, we tend to think of ourselves as private AGs, and I think that's true on the consumer side as well. So as I'm speaking today, think of it in that way, how an AG might respond to some of these types of practices, or how the private law firms would help the AGs to leverage some of their resources so that they can challenge practices that are otherwise considered unfair, deceptive, or abusive. I think the consumer protection provisions of Dodd-Frank fall into two categories. The first being the educational awareness component, or what I would call the sort of prospective side of things. And there's an effort really, what we're seeing is that 1/3 of adults have financial literacy when it comes to credit cards and debt and what compounding interest means. And that's scary because I'm pretty sure more than 1/3 of the adults in this world own, or in this country anyway, own credit cards and use them regularly, but don't necessarily understand the ramifications of what debt they're incurring. So there's that piece of it, and I'll get into that a little bit with respect to mortgages and the different kinds of mortgages that people took on, not necessarily because they thought they could afford them, but because their neighbors were doing it too. And if the neighbors are doing it and getting $1 million mortgage, even though they don't have the income, surely that means they could do it too. And then the second piece of this is going to be about sort of the enforcement side, or retrospectively, once we find a practice that has been abusive, how do we go about trying to enforce it, or what mechanisms exist? The hope, I think, though, is that Dodd-Frank is going to protect both consumers and businesses from their worst instincts, which is to say you get these consumers out there who understand a little bit about the risk but not enough, and decide that they want whatever the big reward is in the short term without considering fully the ramifications in the long term. And the businesses, who are far more sophisticated, have a hard time not taking advantage of what the consumer wants and try to circumvent what would otherwise be considered fair lending. So with that, I think I'll just launch into the three areas that I wanted to cover today. The first one being how the mortgage standards have changed. Secondly, the types of enforcement for deceptive practices and how federal and state laws will come together. And then last, the rulemaking authority that the Cfpb has. So with respect to mortgages, I'm sure all of you have read in the media, my firm's been involved in litigating mortgage-backed securities cases, which basically challenge under the federal securities laws the mortgages that were securitized and sold to pension funds, insurance companies, and other large investors. And the claims there are that the mortgages that were originated and underwritten were completely different than what they're represented to investors, meaning there'd be mortgages that were what they call the no-doc loans, so that you didn't have to verify what your income was, you didn't have to show that you had assets in the bank. It's really horrifying, actually, that you could get a person who works in, let's say, the food industry or some other hourly job who could not put a down payment down on a home, not have, have a very low interest rate, and get mortgages of $600,000, $700,000, moving into a house where, under these ARM mortgages, the interest rate was going to jump up to some amount that they can't afford, but they were thinking, again, in the short term instead of in the longer term. And so how Dodd-Frank has handled this is to create two categories of mortgages. There's the qualified mortgages, and then there's the unqualified mortgages. And for the qualified mortgages, those are the ones where the consumers do verify their income, they do have documentation, the debt-to-income ratio is appropriate, and essentially Dodd-Frank creates a safe harbor for the originators at that point. Okay, these extra regulations are not going to apply to you because your mortgages are fully documented and they're appropriate for the consumers who are taking them out. On the non-qualified mortgages, there's an effort to both avoid incentives to the sellers of the mortgage products to maybe take advantage of consumers who don't have the sophistication enough to know, and also to ensure that the people who take out the mortgages are getting monthly statements that tell them, we really mean it, you're going to be paying a lot more. We really mean it, we really mean it. And so here's some of the provisions that help in that sort of education and awareness process. The originators can't be compensated or get a commission based on the riskiness of the product, right? So you don't want to have somebody who's selling a mortgage get paid 15% because they've now given you the default option that's the riskiest option. And there's a lot of literature out there that says the default option, whatever's presented to a person, is the one that they will initially go with, and they're not going to ask for what's the less risky option. Or I think they would still favor the first option presented to them. The second piece is there had been, for these adjustable rate mortgages, a prepayment penalty. so that you actually were discouraged from trying to get out of your adjustable rate mortgage. And that's no longer allowed. Then there's the new rules with respect to the bank statements, so that every month you're getting a statement that says, this is what you currently owe, and this is what you're going to owe in 6 months. We really mean it. And then at the bottom of that is, oh, and by the way, here's some alternatives you have so that you don't go into default. And so it at least gives you the option of refinancing, renegotiating, and a pre-foreclosure sale. And I think the concern there is if a third of the adults out there, only a third, understand compounding interest, are those warnings going to be sufficient? Meaning, will people really understand just because they get a statement on their bill? I don't know, it's like a cell phone bill. How many people really understand all of the charges that are out there? And my guess is that over time there will be fine-tuning to the statements, perhaps to almost like maybe the ingredients or calories on food labels, a way to sort of highlight the ones that we should really care about so that we don't just get a panoply of this charge might exist and that charge and this charge. And hopefully over time there will become greater clarity and consumers will start to get it a little bit better. But I think that that is still to be worked out. The next area then, so besides the education and awareness piece, is the enforcement side of things. And one of the things that Dodd-Frank did, which was very helpful from a litigator's standpoint, is to say, there's a Supreme Court case called Barnett that talked about preemption and when the federal law might preempt state law enforcement. And Dodd-Frank says, yeah, we know about that, but you know what? The federal laws are the floor, and the state laws can be the ceiling. And so the idea being that whatever the federal law is, if the state law is more restrictive or provides more protection for a consumer, that's the standard that the company is going to be held to. And the only time that there is preemption is if there's an irreconcilable conflict, which is a pretty tough standard to meet. The second piece is that both the Consumer Financial Protection Bureau and private litigators are now able to challenge practices as being abusive. So everybody's heard of UDAP laws, unfair, deceptive practices that can cause consumers to make decisions that they otherwise wouldn't make or to not appreciate the ramifications of the decisions they're making. And now there's this new category of an abusive practice, which is tied to the unconscionability laws. But what was interesting about it is that it also targets the elderly and non-English speakers as being particularly susceptible to the fraud, financial fraud. And so I started looking into this idea of how elderly might be taking advantage of. And the statistics are horrifying, really. It's estimated that $2.3 billion a year are lost in the age bracket between 80 and 89 years. And of course, the people are too embarrassed to report it. And so it's hard to even have that come out and have the regulators look at it. So I think over time, in terms of litigation, this notion of what's an abusive practice, how closely tied it is to unconscionability, and how courts determine what's abusive is really going to play out and get better definition. There was one case recently that actually talked about indexed annuities, and this woman was 83 years old and mentally incompetent. She invests in an annuity, and her quote-unquote boyfriend convinces her that she should take the money out and give it to him, and lo and behold, there's a 15% penalty for early withdrawal. And the fact that she got into the product anyway without really knowing what she was doing, the fact that she was influenced by somebody else to withdraw early and incur this penalty, are all areas that I think need to be sorted out and where litigation will continue. But it was very interesting to me that the elderly are becoming this protected class and what that means and whether that will somehow help them where they otherwise are not really reporting. I think that you still need the reporting in order to be able to enforce those laws. Okay, and then the final area I wanted to talk about is the rulemaking authority, which is as broad and as expansive as one can imagine, but for the fact that the cost-benefit analysis has to be done. And so that may tank the whole thing, near as I can tell. In particular, mandatory arbitration clauses. Dodd-Frank instructed the Cfpb to take a look at that and make a recommendation. And mandatory arbitration clauses have been heavily litigated. Obviously, the Concepcion case dealt with them in the Supreme Court. The people who favor the clauses are suggesting that it's cheaper than going to court And in fact, that then you can pass on those savings to consumers who can have lower interest rates and lower fees. And of course, the critics are saying it's boilerplate language, people don't negotiate it, they don't know what it means, they can't afford arbitration any more than, and you're precluding them from being involved in class action litigation, which is where they could actually be represented without having to pay for a lawyer. So, from the plaintiff's perspective, getting rid of these mandatory arbitration clauses or severely limiting them would be an important piece, because they really have not, there's not a sense that the consumer is negotiating for that or that the consumer necessarily wants it. It's a provision that's been forced on them. And it'll be interesting to see how the rulemaking plays out and what the result is in that area. And then, as Albert was mentioning, another area that looks like it's going to be quite hot is student loans and what's an abusive practice. I know when I was in law school, the big deal was the Barbary loan and then the summer trip to wherever, and it was the greatest deal unless you couldn't pay it back. But student loans stay with you for your whole life, so it's worth knowing and having the clarity and appreciating what those products are doing. So I think from the litigator's standpoint, it's great that there are provisions in Dodd-Frank that look to create clarity and that look to create transparency and that help people prospectively understand the consequences of decisions they're making when they take on debt. From the litigator's stance, at the end of the day, when things go wrong, I think this area of abusive practices is just ripe for litigation, and we will see how that plays out and adds to the already existing body of law in terms of unfair and deceptive acts.
Thank you, Julie. Finally, Rick Holmes from Fifth Third Bank will talk to us about derivatives.
Thanks, Professor Chang. I am last guy on a Friday, beautiful day as a bank lawyer. It's talking about derivatives, so I apologize in advance. I'm going to talk about my experience in derivatives at Fifth Third, which is really focused on the non-security-based derivatives. So the CFTC's rulemaking, so I won't speak to the SEC's rulemaking so far, but I will speak to the CFTC's rulemaking and some of my experience there. So everybody knows the role that derivatives played in the financial crisis. AIG namely had credit default swaps. Nobody knew how much the payments would be. People swooped in, helped out. Fast forward to Bear Stearns, to the Lehman Brothers crisis. I've been through all this. I've been helping with our book to unwind our Lehman exposure. I've been helping with the Bear Stearns situation, and I've been pretty much walking through the regulatory process with my business partners to try to figure out what Dodd-Frank's going to do for us. So what I'd like to do is just take a step back and say, what's a derivative? Then talk about the rulemaking process, then specifically focus on the provision of Dodd-Frank that is causing us to be on phone calls every day, day in and day out. And the one thing I would say is my vote against regulation is that I would have to be on fewer financial services roundtable calls all day long. So what is a derivative? A derivative is a risk transfer agreement, the value of which is derived from the value of an underlying asset. Pretty broad. Use your imagination. Let's say that I work at Matt Bank, right?
Fine institution.
Fine institution. Matt's offered me a job, and he says, come in whenever you want, but for every hour you're late, you owe me $50. And I say, great, sounds like a great deal. So I call my friend Sam, and I say, Sam, I want to buy a contract from you that if I come in an hour late to work, you pay me $50. I never come into work. I pay you $50 that I get from Sam. That's my work derivative. Pretty sweet deal. But Sam's going to charge me a fee, a premium. The premium's probably going to be more than $50, so it's probably going to be a bad deal in the end because he's going to realize what the risk is for him. Insurance companies buy derivatives on weather. If they have properties on the east coast of Florida that they think are going to get hit by a hurricane, they buy a derivative to protect their interest. Commercial entities buy interest rate derivatives to fix the variable rates of interest that they have to pay on loans. I've even heard of a litigation swap where if settlement offers are made in a piece of litigation, payments get made to a certain party. Pretty interesting concept. So if derivatives are so broadly used and the market's out there for people to hedge their risk on exposure, why have they become so vilified? And I think somebody earlier asked whether the EU's banned naked credit default swaps, where you don't have an interest in the underlying obligation. They have banned sovereign naked credit default swaps. I don't know if they've banned other than sovereign yet, but I know they've banned sovereign credit default swaps. So the real problem with derivatives is people making bets on things that they're not hedging risk, and that creates turmoil. People don't know where the payments will come, and we haven't been able to follow the money. So Dodd-Frank was enacted to bring transparency to this very opaque market, to bring regulation where there's really only been, at best, prudential regulation by regulators who don't really dig in, and to cover those places that aren't otherwise regulated with a regulatory scheme. So then you ask the question, okay, if this is about people entering derivatives that are naked or about the credit default swap issues, is that all what Dodd-Frank is about? And the answer is no. No, it's about all swaps. It doesn't discriminate. Any swap which is sold by a bank is potentially regulated, and we'll see someday whether banks will become subject to this. But before I go into what the rules say, I want to give you a couple facts about the derivatives market. The OCC puts together a quarterly report on derivatives positions, and I have the report for the fourth quarter of 2011. And this is the top 25 banks in the U.S., what their exposures are. So the total notional amount outstanding, and notional means principal, means the contract value, for derivatives in the fourth quarter of 2011 was $231 trillion. It's a big number. But that doesn't mean that if those contracts trigger, there will be $231 trillion in payments. That's just the principal amount. The value of the derivative is based upon the market. The market changes daily. It goes from one counterparty to the other. It increases and it decreases. The real risk in derivatives is the credit risk that's tied to the market value of the derivatives. If you look at the same $231 trillion number for that same period, the credit risk associated is $430 billion. That's the net credit exposure. Now, net is an important concept there because if you have collateral protecting your market value, you decrease that exposure by that collateral. It's also important that people always hedge the risk that they have in derivatives contracts in the market. So that's considering everybody's paid everybody and that nobody's failing on their contracts. The net exposure will be $430 billion according to this study. Another important thing of the study is it really shows the top 25 banks. You saw some of them on Albert's presentation. The top 5, JP Morgan, Bank of America, Citibank, Goldman Sachs, and HSBC, constitute 96% of that total notional amount outstanding. The remaining 4% is in the other 20 big banks. So of the market, you have these 5 banks at the top controlling the majority of the market. And why is that important to us? Because what we do when we talk to the CFTC, when we go in and we talk to Chairman Gensler and his staff and the other commissioners, we say, don't do this to us like you're doing it to JP Morgan and to Bank of America. Why? Because we rely upon them. We're the small players in this pool. We rely upon them for their systems. We rely upon them for their prices. We're really a price taker from them. We look at them and we say, we have a customer that has a need. How much will it cost us to buy something from you so that we can hedge our risk when we sell it to them? So our argument is you shouldn't apply this to everybody the same way. You should at least say, apply it to them first and then us later. We'd really like them to say, okay, we'll apply it to them and not you, but we don't think that's going to happen. What we've also said is, look, if this becomes too burdensome for us, and if you apply this to big banks and us at the same time, economies of scale might make it such that we're going to leave the market for certain products, okay? And if we leave the market for certain products, certain customers aren't going to be able to trade what they trade today. They're not going to be able to hedge their risks of their commodities because JP Morgan, big banks like that, don't do business with this size customer generally. They just can't get into that credit relationship. We're there for a pretty important function. We have a middle market clientele that is our sweet spot, and if we were to go away, it would become very expensive for these people, and maybe even prohibitive. So, focusing on CFTC, I think everybody's already heard today, Dodd-Frank requires almost 400 rulemakings. 64 of those are required by the CFTC. They've missed 24 deadlines. They've finalized 36 rules. The statutory provisions which say a swap dealer, and I'll talk about what that means in a minute, has to do certain things, went into effect last July. So these swap dealers, and we don't know who they are yet, are potentially violating a statute. Now, what did SEC and CFTC do about that? They said, we won't enforce it. Now, for some of the professors in the room, that might be an interesting debate about whether somebody could get out of a contract, right? We hope there's no private right of action, though. So the CFTC is really struggling to write these rules. Gary Gensler, in a recent hearing of the House Committee on Agriculture, told that committee he's got a staff of 700. He needs $100 million and 300 people just to start helping him comply with the rulemaking process. What I say is, if he can't get the rulemaking done, how is he going to be able to enforce, to audit, to really make a difference and make the transparency and regulation happen that's intended? And one of the meetings that we attended with Chairman Gensler, I'll never forget what he said to us. He said, he noted our concerns. He understood that we wanted flexibility. He understood that things should be different for us than for others. But he said, a starved regulator is an inflexible regulator. And then he said, we need funding. Kind of an interesting meeting. So now to the substance of Dodd-Frank. I want to tell you real quickly about the different types of products that we sell to our customers. And I know this could get a little complicated, but I'm going to try to simplify it. And there's a lot of ambiguity about what each of these products could look like in the end. We sell swaps, we sell forwards, and we sell options on various different underlying assets. Any commodity, foreign currency, interest rate derivatives. A swap is what it sounds like. It's an exchange of streams of payments. If I have a loan that's variable rate and I'm worried rates are going to increase and I want to get a fixed rate on that loan, I can buy a derivative from Sam where he'll pay my variable rate obligation and I pay him a fixed rate. A forward is kind of like a swap, but it's really only one payment. It's a promise today to pay it sometime in the future, today's price for something. Okay? And then we also sell options, which are very similar to forwards, but they have different triggers in them and different mechanisms. So I'll speak in terms of swaps and forwards. Dodd-Frank regulates swaps. Not the same swaps I just talked about, but whatever the regulators define as swaps. They've defined everything that we do, commodity, foreign currency, interest rate, products, as swaps except for forwards and spot FX transactions. So effectively everything we do, we might be subject to Dodd-Frank's rules to register as a swap dealer. So what's the impact then on us of that? Swap dealers have to register as swap dealers. Major swap participants have to register as major swap participants. Dodd-Frank defines a swap dealer as any person that holds itself out as a dealer in swaps, makes a market in swaps, regularly enters into swaps with counterparties in its ordinary course of business, or engages in any activity causing the person to be known as a dealer or market maker in swaps. So anybody, even Sam. Major swap participant is something which is defined based upon nominal amounts of swaps that you hold. I won't go into the specific details. What we are worried about and what we are focusing on is whether we'll be a swap dealer. And you can be a swap dealer for each and every different type of product you do. All of them, none of them, somewhere in between. So, what are we focusing on? In the meetings that we have with the regulators, the comment letters that we write, the conversations we have, our lobbyists say, there's a possible exemption that Congress gave you. And the exemption they gave in the statute reads, you're not a swap dealer if you offer to enter into a swap with a customer in connection with originating a loan with the customer. Offer in connection with a loan. Okay. The CFTC came out and they said, you've got to do it at the same time you sign the loan document. So they've substantially narrowed it. They've said it has to be contemporaneous. That's the first proposal. We're waiting for the last proposal. It's tied up in a lot of political and regulatory debate right now, whether that will be broadened back to where I think Congress intended it, or whether it'll be very narrow and we'll have to register as a swap dealer for everything. So there's also, from what I hear, the possibility of a pretty meaningful de minimis exception to registering as a swap dealer. The initial proposal said $100 million a year, you won't have to register as a swap dealer, but you have to look at your whole book. And everybody said that's not going to be useful to anybody. So we're hearing numbers in the $2 to $3 billion range still applied to the whole book. And we believe that we may fall into that at Fifth Third. So why do we care that we register as a swap dealer? Well, it adds what we don't think is necessary. We believe that prudential regulation and our relationship with our regulators in their supervisory capacity helps us mitigate our risk and protects our customers sufficiently. We believe that the institutional marketplace that derivatives are traded in is a sophisticated marketplace, notwithstanding what happened with AIG, notwithstanding what happened with Bear Stearns, notwithstanding what happened with any of the counterparties to any of these transactions. Some of the impacts for registering as a swap dealer, one of the most unusual ones is you have to hire a chief compliance officer. It has to report to the effectively chief executive of the swap dealer. So that means for a business line which has less than 1% of revenue at Fifth Third, we have to hire a CCO that reports to Kevin Cabot, our CEO. So that's something that we're dealing with. You have to effectively have all of your people potentially licensed. We think we're going to go to a license for every person, just like in broker-dealers. Trading has to be monitored. There has to be a robust risk management function that the CFTC likes. That's the potential for regulatory confusion because the Federal Reserve has a very different view of risk management than the, I'll call them enforcement regulators. We have to provide increased information disclosure. We have to have links to trading facilities. We have to put in systems which get us access to markets to clear derivatives. We have to come up with very stringent conflict of interest policies and procedures. We have different margin requirements. Our clients will now be required to place margin with us. That's a cost they don't have now. We'll have to have daily trading records provided to our regulators. Business conduct standards will elevate. If we deal with municipalities, with employee benefit plans or government plans, we will effectively be their fiduciary. The regulators are going to put in, like in the insurance world, documentation standards on our documents with our customers. We can only trade with eligible contract participants. That one's not as worrisome to me because we really only do that anyway now. If we hold collateral for our clients, then we have to register as a futures commission merchant. We've now got another reason to regulate. And all of this is just additional costs that we don't consider to be necessary. All of this puts us in a position, like I spoke of before, to have an economy of scale that just may not work for us. So we're trying to get relief. We're trying to get relief. That's really the swap dealer provisions. One thing also to talk about in what Dodd-Frank is doing relative to derivatives is the push-out rule. Now, the push-out rule says that a bank can't access the discount window, and the banks access the discount window to fund loans. It's a very convenient way for us to get capital. And they can't get FDIC insurance if they offer commodity swaps or security-based swaps to their customers. So that means every one of those things which we have now, we have to put into a holding company sub that's not under our bank. That means that in addition to the bank, if it's a swap dealer, we have another entity that's a swap dealer. So now we have two swap dealers.
And this other swap dealer will have other capital and compliance requirements. We'll need a staff of people to help it with its troubles that I just went through. It's just increased cost, increased burden that we don't think we need. So that's another thing. That will happen in July of 2013. The last thing I'd like to talk about briefly is the Volcker Rule. We may have mentioned that earlier today. I don't know. And the Volcker Rule is a provision which was put into Dodd-Frank championed by Paul Volcker, which substantially reduces banks' ability to purchase securities. Right now, banks are able to do things because statute permits them to. Unlike a corporation, a bank has to have a statutory provision that it can point to and say, that says I can do what I'm doing. Corporations just need to do things which they're not prohibited from doing. So the National Bank Act gives banks pretty relatively broad powers to purchase securities. Regulations promulgated under that set out a categorization of the types of securities the banks can buy. And as you can imagine, the less risky, the more we can buy, the more risky are capped based upon our capital levels. So what's the Volcker Rule do? The Volcker Rule says no more proprietary trading for your trading book if you intend to profit in the short term. The Volcker Rule was proposed in August, I think. Was that right? Yeah, August. 298-page proposal, 1,400 questions, received 17,000 comment letters. So what it says is everything that you buy is short-term. We're going to assume that. And you need to prove to us that what you're buying is for a valid purpose. You have to document your hedging activity at your holding company level. So if you have a huge debt offering that has a variable rate interest and you want to buy a $100 million derivative, you have to justify why that derivative hedges that debt offering's risk. And you have to test it from time to time to make sure that it's still effective. And you have to prove that to us on an ongoing basis. If you buy securities at your broker-dealer, you have to prove to us that you're buying them not for profit, but to sell them to customers, to make markets, or for other valid purposes. There's something called the Market Risk Capital Rule, which this is a lot like, but it's really going to change the way banks buy and sell securities and document what they're doing. So what's the interplay between the swaps rules and Volcker? Well, if you can't get an exemption from certain transactions being subject to regulation, then what we're hearing is the logical conclusion is that the regulators will assume that it's short-term banned proprietary trading, even in the derivative space. So that's another troubling thing that we have to deal with. We anticipate that the Volcker Rule is going to become final sometime soon. We know that the implementation date has been proposed by Barney Frank to be pushed back till September. Everybody understands that on that and on the entity definitions, the swap dealer definitions, there's a lot of work to do, and they have a lot of implications, monetary and otherwise, for banks and their customers. So that's about all.
Thank you, Rick. Thanks to all our panelists for giving us a really well-rounded perspective on how Dodd-Frank has affected their practices from the defense, plaintiffs, and in-house counsel perspective. We have some time for questions. Any questions? Yeah.
I've got one for Matt and Claire. We talked about whistleblower provisions and the fact that there's no mandate for whistleblowers to first use their company's reporting mechanism. We also talked about the fact that there is a retaliation for someone blowing. I wondered if those covered, if a company has a code of conduct policy that requires their employees to report things that they see through their internal means, could that employee be, in fact, punished in some way for violating that internal company policy and not reporting?
So I'll just rephrase really quickly for the purposes of our webcast. The question is, if a company has an internal policy that requires an employee to report the conduct and it is in fact not reported, could that employee be reprimanded or disciplined? Question is for Matt.
And Claire.
And Claire.
You want to go first, Claire?
I think if it's not a person who is, there's a special category of people who are compliance officers, and they're in a special category, but I took your question to be just your average person. Could the company say you are required to report to us and not the SEC first? I think there would be a pretty good argument that that's circumventing the rules that the SEC put in place, which is to say that you don't have to do that. Does that mean somebody wouldn't do that and argue that that's a legitimate basis for punishing, we're not punishing you for going to the SEC, we're punishing you for going to violating our rule? Sure, I mean, we might hear that argument, but I think that would not be a winning argument.
Yeah, I think under the way the law is structured, Claire is probably right, but I think it further demonstrates the unfortunate tension where employees can circumvent otherwise a code of conduct or internal policy that would require, internal reporting, which the reason you have a provision like that is so the employee escalates it immediately and it can be dealt with.
That might be one of the reasons.
Any other questions? Okay. Well, Barbara, do we have final words?
Actually, we're right on time.
Okay.
Thank you.